Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Erica Adler, shareholder at Retzel and Andrus and leader of our healthcare practice. Today, I have my shareholder, Christina Kuda, with me, who's also a member of our healthcare practice. And this is our first podcast of 2025. So, what we want to talk about today is a very recent update that was provided by the state of Illinois on med spas, providing clarification specifically related to the ownership of med spas by nurse practitioners. And then we also kind of want to give an update on med spa ownership generally, which applies to many states. So welcome. And Christina, of course, thanks for being here.
Thanks for having me.
All right, so let's jump right into this. We have talked about med spas many times. They are growing in popularity. And one of the biggest questions that come up again and again is who can own them? Who can operate them? And we talked at different times about the various structures that can be used to allow for ownership. Where a physician may be just one of the parties that's involved, and there are other non-medical people involved as well. So let's just kind of backtrack a little bit and say, tell me generally who can own and run a med spa, and what this update in Illinois tells us about med spa ownership.
Sure. So, as we have been advising clients for a while now, guidance from IDFPR that recently came out within the past month actually has confirmed that a medical spa has to be owned by a licensed provider, either a physician or for the first time they've actually acknowledged in writing that an advanced practice registered nurse, an APRN, also may be able to own a medical spa. If any of the services that are being offered are determined to be a medical service in nature and the entity is holding itself out as a medical spa, it must be one of those two owners and it must be owned through a professional entity. So for APRNs or physicians, it can be a professional limited liability company or a professional corporation. And for physicians only, it could be a medical corporation.
Okay, perfect. And of course, just a reminder that forming the entity is just the first step. You actually need to get a license. In Illinois, that would be with the IDFPR. In other states, that would be the equivalent in those states. So once we have either the nurse practitioner or the doctor owning the med spa, can it continue to be referred to by any name we want? That is, with a nurse practitioner owning it, are we allowed to use the word medical?
So it appears from the guidance, they make no distinction between the use of the name medical for the name of the entity, whether it's owned by a physician or owned by an APRN. Certainly, any type of entity that's not providing a medical service, like a general spa that maybe is just doing facials and things that are not considered the practice of medicine, cannot use the term medical at all, because that sort of assumes that it is a medical entity. But nothing seems to give a distinction between a physician and APRN owning an entity with that name.
Okay, perfect. So the nurse practitioner, if they are the owner, do they need to be able to practice independently? And that is in Illinois and many other states, you can achieve the right to practice independently, which is that you have met a certain number of hours or qualifications. You no longer have to have a supervising or collaborating physician. Do you need to have that status, or can a nurse practitioner be someone who can own it and still require the supervision or collaboration of a physician?
Yeah, so a nurse practitioner who is still in a collaborating practice without full practice authority can own the entity practicing within their scope of practice. Here in Illinois, you need to have a written collaborative agreement, which is also a requirement in many other states, and they need to stay within their scope of practice. So that collaborative agreement generally says what sort of what categories of services they may be allowed to provide potentially. It also speaks to what prescriptions they can actually prescribe, et cetera. But within meeting those guidelines, it shouldn't be an issue.
Okay, perfect. So what I'm hearing you say then, just to be clear, is that a nurse practitioner who has not achieved independent status could still form the entity, get it licensed with the IDFPR, and run the med spa subject to having a collaboration agreement or supervision agreement. So this is not limited to those people who only have independent practice. Of course, certainly much easier if you go out and get that independent practice. But I think I just want to make it very clear to those that are listening that may be working on becoming independent but have not yet, that they can do this. And of course, everybody needs to check in their own state to find out how this distinction is. So whether it's a nurse practitioner or a physician that is the owner of the med spa, sometimes there are people who are not licensed who also want to be involved in the med spa. And you and I have talked about this before. A very common structure is to use the physician or the nurse practitioner as the owner of the med spa, and then to have a management arrangement with a management service organization, an MSO. And a lot of the business and management services are then provided by the MSO, and they get paid a management fee. And in the past, we've talked about the importance of whoever that licensed individual is being actually involved in the practice and not just allowing their name or their license to be used. And I kind of want to talk about this again because we really can't talk about the med spa industry at all without letting people know how common it is for physicians and nurse practitioners to be brought into med spa arrangements and to sign on to the formation of an entity, but to really not maintain the appropriate involvement. So I want to make sure that we're really clear, other than just being the proper owner of the entity, what is required of that licensed provider?
So the licensed provider has to be aware of what is happening at the medical spa facility and have involvement. So, like you said, we see a lot of circumstances where physicians, some will go to a physician and say, I'm not licensed, but I'd like to operate a medical spa. I'm going to form a management entity, but here in the state, you have to own the medical spa. Are you comfortable with doing that? And a lot of times, maybe for friends, family, help, they will agree to do that. And then they have nothing to do with the spa. They literally are just the owner. The problem is if that spa is not being operated correctly, then that physician owner can still be liable for actions that are happening, particularly through state boards, like here in Illinois, the Illinois Department of Financial and Professional Regulation. We've had clients that have gotten notices from IDFPR regarding their affiliation with the medical spa and not being happy with the fact that they've had no involvement with the spa that they own. The other issue is a lot of times these medical spas provide services like Botox, for example, or weight loss injections. Those have to be ordered and prescribed by a healthcare provider. Many times, these spas will go ahead quickly for Botox and just use the provider's, NPI to order all the Botox, and will have nurses that will, inject the Botox as they see fit. That's not proper. There has to be an evaluation of the patient first. Physicians should not allow their NPI number to be used to buy medications unless they're involved in that process, understand what's going on and happening. So a hands-off approach by saying, look, I just owned it, I had nothing to do with it, isn't helpful because you've basically said you've abdicated any responsibility for determining that that facility was running appropriately to somebody else. And that's not something that's going to get you out of trouble if trouble finds you.
Right. And not to mention that there's malpractice liability. So if something goes wrong there, the doctor probably never met the patient or knows anything about it, and they're going to be on the hook. It's their medical practice, literally. I guess even a bigger issue might be that if a nurse practitioner is the owner and has a supervising or collaborating relationship, and neither the doctor nor the nurse practitioner was really involved, then they're both going to be dragged into it. And so, it's really important. I think in most cases where I see nurse practitioners owning med spas, they do intend to be involved. I find them less peripherally invited to be owners than doctors. A lot of doctors seem to do it because it's an easy source of monthly income, or something like that. But it can cost you a lot if you're not careful, and it's just not worth it. So
Financially, it's never going to be worth what it could do to your license and the rest of your career.
right. So we talked about some of the services offered by Med Spa. And one of the interesting things that this guidance in Illinois did was kind of muddy the waters a little bit as to the type of services that they don't want to see happening within med spas and who can and can not perform certain types of services. So why don't you speak to that a little bit?
Sure. So some of the clarity they did provide, and this sort of piggybacks on prior guidance they've given, but it's been many years, is that things like Botox, chemical peels, collagen injections, liposuction, certain microdermabrasion procedures, dermaplaning, microblading, microneedling, radiofrequency, hydrofacials, laser services, and weight loss injections are considered the practice of medicine. So those procedures have to be, patients have to be evaluated first by a healthcare provider within the scope of their practice to determine if they're appropriate for the procedure. There has to be a patient provider relationship, notes have to be created, etc. At that point, anyone who's within the scope of their practice to provide those services can do so. Also, a physician can delegate certain services to unlicensed persons who have the requisite education, skill, and training to provide the service, as long as the provider is on site when that service is provided. And one of the things that the guidance talks about is like cosmetologists and estheticians. So a lot of times, at these medical spas, physicians may delegate responsibility for certain services that are considered the practice of medicine to estheticians. Well, under the law, estheticians cannot hold themselves out as estheticians when they're providing services outside the scope of their practice. So if a physician delegates, let's say, a dermaplaning procedure to an esthetician at a medical spa, that esthetician cannot hold themselves out as an esthetician. Can't say esthetician on their badge, can't tell the person that who they're treating, I'm an esthetician. They're essentially an employee of the medical spa who is working under the supervision and control of the provider. Where it got a little interesting is the guidance makes it clear that certain procedures that are esthetician scope of practice procedures, like let's say a general facial, that service really needs, anyone providing that service needs to be registered as a salon. So it also says that you can't be a salon and a medical spa. So what's kind of unclear by this guidance is if own a medical spa as a physician and I'm going to offer services that are definitely the practice of medicine, but I also want to have patients come in and get a facial if they want, can I not offer a facial at all because I don't have a salon license? Or can I offer a facial, but the person giving the facial can't hold themselves out as an esthetician because they're working for a medical spa? That actually I don't think was clear in the guidance and is probably worthy of some follow up with IDFPR.
Okay, perfect. Yeah. And just to be clear, this isn't just a theoretical issue that Christina's talking about. We literally have had the IDFPR investigate when estheticians are providing services under the supervision of a doctor that are services outside their esthetician license. And yet they were either identified on the website or by a badge or otherwise as being an esthetician. So this is not just a technical item. This is something we've actually seen enforcement of. I think you and I agree that, they are probably putting this out to respond to a lot of questions.
Mm-hmm.
We have seen some recent investigation in this area. Do you think all of this is leading up to increased investigation? Where do you think they're going with this?
Absolutely. And I also think this is probably in response to questions. They've also given some guidance historically in different guidance documents, and this kind of puts a lot of them together as well. I'm suspecting a lot of this is borne by the proliferation in the last year of weight loss injections and weight loss drugs. Because I have seen so many, I mean, in the Chicago area where I live, I can't drive around 2 blocks without seeing a sign that says weight loss injections here, come get your weight loss supplements. And there's no obvious sign that says it's a medical spa or a doctor's practice. So I'm not sure who's providing that or who's giving out those drugs. So I suspect that is what sort of brought this on. But yeah, I think enforcement's ramping up. I think at this point, IDFPR has realized that a lot of medical spas don't operate properly. We see this in our practice all the time. Spas come to us and we have to tell them you have to totally unwind. You're not doing this. I just met with a new client a couple weeks ago who wanted to open a big clinic to provide all these services, and they went to a lawyer who didn't understand healthcare law, and he set them up as three unlicensed owners for a basic limited liability company. Right there, that's wrong. So I think a lot of people weren't aware of what's going on and weren't doing things properly, and IDFPR's caught on. And I also think, too, that it now is going to be more difficult to defend actions before IDFPR or other licensing authorities, particularly in other states where there may be similar guidance or similar rules. And there are a lot of states that have particular rules about operating med spas. It's going to be hard to say, well, I didn't know. I went to a lawyer. I went somewhere. I really thought I was doing this properly. They have put out a guidance document dated early December 2024 on their website about how you have to operate a med spa. So even though ignorance usually isn't an excuse, sometimes it'll get you a better outcome. I don't know that that's going to happen anymore because they've put it out there for everybody to see how this has to be done.
Right. I absolutely agree. And that's true for lawyers as well. There's really no excuse for a lawyer not to be up on what the law is, especially now that this clarity has been provided. And in most states, there is clarity as to the rules related to med spas, who can own them, and the services that can be provided. So a little bit of research goes a long way. One related issue that I wanted to mention is that um, physicians and nurse practitioners tend to think of family members as different than um, patients. Okay. And this is somewhat unrelated, but often comes into play with the very same people who are owning med spas, running med spas. These cosmetic medical services, weight loss drugs, Botox, etc., are very popular. And we often will have nurse practitioners and doctors being invited to do, Botox parties and, weight loss drug injection, sometimes just for friends, but very often for family. And I think one of the things we should touch upon here is what are the requirements and are they any different for friends and family versus normal patients that come to your practice? And what are the repercussions for not handling things properly?
Yeah. So it's a really, really good point. Absolutely. Friends and family. I'm guilty of it too. I have family members that are doctors, and sometimes I'll call them and, want a prescription or something. So, we're all sort of, it's easy to do, right? And if you're a physician, you want to help your friends and family. They have to be treated as regular patients. Physician patient relationship has to be established. A note needs to be kept just like you would keep any other patient notes. Proper assessment. They should not be treated any differently than you would treat an actual patient who wasn't related to you. And this is another enforcement issue that we have seen where even physicians with their own children have prescribed medications or have prescribed certain services. And there's, for some reason, IDFPR's got to complain about something. They start to investigate and they realize there's no note, there's no analysis, there's no assessment. They just wrote the script or called it into the, pharmacy and nothing was done. That's dangerous. It's also potentially dangerous from a malpractice perspective. You think your cousin's never going to sue you, but if something really goes bad, your cousin might. And your malpractice carrier may say, we're going to have trouble defending you, or you could even void parts of your policy if you did literally nothing to the standard of care because your cousin called and said, I want, Wegovy for weight loss, and you just sent a script and didn't do an analysis of their health or what medications they're on or whatever the basic standard of care would be. Also, although most of what we're talking about are not controlled substances, a lot of states have rules about prescribing controlled substances to family members, and some prohibit it. So you've got to be particularly careful if there's a controlled substance issue. But we always tell providers, treat family and friends exactly how you would treat a regular patient. And if they hem and haw because they're not happy about it, just explain it's a license issue. And, it's a liability issue.
Right. So yeah, when you're setting up, and the reason I'm mentioning it here is because these Botox parties or whatever, or cosmetic parties are so popular. So when that nurse practitioner is coming into the party, everybody should have completed patient paperwork, and there should be documentation and evaluation. Like it may not be that everybody there is a good candidate to receive something, but everybody's getting it no matter what. I would really question whether the requirements are being satisfied. So that's a real risk. Now, obviously, the risk is more here to the provider and the business. There's a medical risk to the patients, but I think these things kind of fit together. So if you're the one going to a Botox party, you could look at this as well. I also want to mention that what's become really popular in many large cities, including here in Chicago, are mobile cosmetic medical services. So we're seeing a lot of services where people will just come to your house for Botox injections and other cosmetic services. These same requirements are in place. The person providing it must be a provider who's able to evaluate you, or they must evaluate you and then send someone who's under their direction. If that person is not appropriate license, it's just a lay person, they may need to be present when those services are offered. Everything you have just said continues to be important, even if it's a home-based service. So,
And to that as well, another caveat with a home-based service is making sure the environment's appropriate for the service. There is a presumption that there's a standard of cleaning, a standard of infection protocol in an actual provider's office. That may not be in someone's house. So if you walk into someone's house and it is not a sanitary or clean environment, and you're now going to pull out needles and put it in their face, you probably want to assess and determine, is this an appropriate environment to provide the service? Because if it's not and something happens to that person, you're going to have more liability and more issues with potential malpractice.
Right. And I know that one of the things in the guidance had to do with, the potential infection issues as well. So you want to speak to that?
Yeah. So the guidance, this is interesting because I'd never seen this before related to guidance for our med spas, formal guidance, but particularly it discussed the fact that medical spa services are, highly subject to potential infection issues or potential adverse events. I mean, certainly there are other services like surgeries and things that are, way more likely for that to happen, but you are doing injections and things and lasers, so there may be issues. And the guidance pointed to like the CDC guidelines, OSHA standards, and some National Med Spa Association guidance that practices can follow and look to determine if they have appropriate infection control and adverse event control procedures in their operations.
Okay. So, and that's just guidance. If you're going to someone's house and it's not super clean, it doesn't mean you can't do the injection there, but you should be aware that you may not be uh, meeting those CDC standards.
And
Got it.
take additional precautions while you're there.
All right, perfect. Okay, so anything else you want to add? We've covered really a lot here. Who can own a med spa, the type of supervision that's required, the type of services that can be offered, as well as some precautions that should be taken to avoid, violating, state laws. Is there anything else you could think of that we want to remind everybody about today when it comes to med spas?
Sure. So if you're listening to this and you're involved in a med spa or own a med spa or thinking of owning a med spa, particularly if you already own or operating, don't assume because you haven't had an issue yet with IDFPR and you've been running operations the way you have, you're just going to continue. A lot of people don't want to take the time, effort, or expense to sort of fix an issue. You need to make that effort because I think this has shown us that there is going to be additional enforcement, and it's better to sort of, if IDFPR knocks at your door, it's better to tell them we're doing everything right now. We maybe weren't a year ago, but we understood we were doing something wrong. We've cleaned it up. We've fixed the practice. That's going to get you a lot better outcome than if they show up and you're still operating in a way that's opposite or in contrast to this compliance guidance. So as much as it's a hassle and it can be an expense, take care of it now.
Absolutely. And, one of the things you and I do very often is fix what others have set up improperly. And this very often comes up when somebody's trying to sell their med spa or bring in a new owner, and a lawyer is looking at it for the first time and saying, wait, what is going on here? And then it turns out the original advice that they were provided was incorrect. Even such basic things as the type of entity that they're using, and things like that. So really clean up your house in as many ways as possible. And a lot of people think that because med spas are largely cash-based businesses, that they don't really need to worry about the law as much. Nothing could be further from the truth. We're talking about the license of the nurse practitioner, the license of the physician, the license of the entity. So this has nothing to do with whether you take Blue Cross Blue Shield or Medicare, or whatever. This is state law. So that's kind of a misunderstanding that a lot of people have, because very often things are focused on insurance-based practices. But all right, well, I think that's probably it. If anybody has any questions, wants to talk about forming a med spa, talk about concerns they have with their own med spa, or something they've been asked to do or be involved with, please reach out to myself, to Christina, and feel free to email us or call us, whatever you prefer. We're always happy to answer questions. This has been the Health Law Hotspot. We're very excited that you joined us, and we hope to see you next time. Thanks so much.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.